Welcome to Wynnes IP Insights, where our goal is to inform businesses and inventors on intellectual property, so you can better understand the benefits of IP protection and how to leverage your IP assets to maximise business growth and financial returns. To start off our patent series, we'll be going to cover the importance of filing a patent. We will talk about the commercial benefits of patent protection and the potential consequences of not controlling your intellectual property. First and foremost, patents and patent applications don't exist by themselves. They're always part of a bigger business plan. Ultimately, a patent or a patent application should provide you with value. Now, they do this in a number of ways. Firstly, they can distinguish your business from another business. They can deter competitors from copying the same product. They can be licensed to a third party, or they can be sold outright to a third party. They can also be recognized on the company's asset ledger, and they can be used as a marketing tool to let people know that a business has invested money into research and development. When it comes to patents, you can seek protection for new and inventive machines, apparatus, assemblies, devices, and widgets. Chemicals, biological processes where a new result is produced, packaging if it's distinctive in how the product is presented to the customer, kits and parts of apparatus or assembly, synthesized chemicals and biologicals, computer hardware, as well as software, IT, and business methods, providing that a tangible effect is produced. If you've developed a niche product or process, you must protect the IP in order to maintain ownership and control over the invention. A patent provides you, the patentee, with a monopoly to exclusively exploit the invention. In practice, the patent provides you with a market advantage over competitors and gives you time to secure market leadership in the relevant area of technology. With a patent, no one can legally copy the invention without obtaining authorization from the patentee. It's important to note that as soon as you begin discussing your invention with anyone, be it friends, family, or a manufacturer, you are jeopardizing your chances of successfully protecting your invention. At the very least, you should have a confidentiality agreement or a non-disclosure agreement in place with anyone you talk to. Ultimately, you should speak with a patent attorney as soon as possible so that you know exactly what you can do to protect and keep control of your idea. As patent attorneys, we're obliged to keep everything confidential, so you can talk to us about your invention in as much detail or as little detail as you wish. There are potential risks that you should consider if you decide not to seek patent protection. If you've not applied for a patent application before releasing your invention to the public, you could lose your rights to your intellectual property. Public disclosure of an invention could allow your competitors to freely use it for their own commercial benefit. You may not be able to backtrack and apply for a patent application for a publicly disclosed innovation at any point in the future. There are some grace periods, for example, in Australia and the US. However, there are no grace periods in most countries around the world, and any public disclosure can jeopardize your rights in those countries. Now, one thing I do get asked a lot is, why can't I just file my own patent application? Well, the problem there is that most people who file their own patent applications don't know the ins and outs of how to draft a patent specification, and they can easily make a fatal mistake. Now, patent application is quite expensive, but again, it comes down to the value that it provides you. And if you're going to sell the patent, or if you're going to license the patent for multiple $1 million, a couple of $1,000s to have it drafted is a very small price to pay. If you have a trademark, patent, or design inquiry, fill in your details below and book your free initial consultation. or give us a call so we can help you identify and review your IP assets with zero obligation.